Niamh Dunne, Miguel Sousa Ferro, Justin Lindeboom, thank you very much for your availability, for agreeing to discuss a very interesting case, which is a recent case, and the potential repercussions for the future enforcement of competition law and sectoral regulation is quite visible. We all know that competition law is enforced not in vacuum. We have other areas of law which are in constant communication, in constant dialogue, and there is often a conflict of the primacy in terms of which area of law should be enforced, and how different areas of law coexist, how they interact, etc. There were several landmark cases in the past which different jurisdictions had an opportunity to reflect upon this. In the United States, in the European Union, we will be talking about the European Union, and we have a recent case just adjudicated by the Court of Justice of the European Union, the station and service, and we have also two op-ed by Miguel Sousa Ferro, published by European Law Live probably 3 weeks ago or so, and then Justin Lindeboom has responded to this set of ideas. Both papers are really appealing and really, really topical. So I had an honor and pleasure to invite these two guests and also another stellar antitrust thinker for this improvised panel, so that we can reflect our ideas on the case. But we will start with Niamh, who will very briefly, from her textbook, landmark textbook author, Towel, one of the highest in antitrust world, just remind us briefly the facts of the case, and then we will ask Miguel to present his interpretation, his reading, and then followed by Justin, and then we'll have a dialogue on these topics. Niamh, please.
So thank you very much, Alice. It's a great privilege to be on the panel. So DB Station deals with what on its face looks like a relatively straightforward question. To what extent can Article 182 be applied to fees that are charged for access to railway infrastructure that are alleged to amount to an abuse of dominance? And I suppose the answer, if you're kind of thinking generally in EU law, very straightforwardly, unless the state action defence applies, Article 102 is fully applicable. But we're dealing with a very specific area of law here, and these charges were levied under the Directive 2001/14, the Railway Liberalisation Directive. And there's a line of case law which states that in this particular area, the specific regulator, the national regulator in each member state has what in the CTL logistics case was called exclusive jurisdiction to consider the legality, the acceptability of those fees. So in the CTL logistics case, and then in a subsequent case, Koleke Mazweki, apologies for my terrible Polish pronunciation, the court said that essentially, the Court of Justice said that national courts don't have jurisdiction to re-review those fees, that it falls within the exclusive competence of the railway regulator. The question in DB Station is it different if we're dealing with one of the hierarchically superior norms of EU law, Article 182, the earlier cases which had taken this very hard line that the regulatory regime outs the jurisdiction of the domestic courts, both dealt with domestic legislation, the paragraph 315 of the German BGB, and in the Polish case, it was national law which was implementing essentially the Frankiewicz principle, but in a way which was much more permissive than Frankiewicz itself. And so the question is, do things change when it comes to Article 182? And the court says, actually, Article 102 remains directly effective. The railway jurisdiction, the railway directive doesn't oust the jurisdiction of the national courts, but it took quite a peculiar, perhaps, approach, and it stated that the application of Article 102 is subject to two necessary preconditions. First, it's necessary to first go through the regulatory regime to appeal the charges to the domestic regulator. And secondly, it stated a duty of good faith cooperation between the regulator and the national courts, which are which would be subsequently adjudicating on the Article 102 question. And I know both of those elements have in the op-eds generated quite a lot of discussion between the other panelists as to whether they are compatible, make sense with EU law generally.
Thank you very much, Niamh. So, Miguel, can I pass the floor to you? I know that the opinion of Advocate General and the judgment itself were slightly different, let's put it this way, but who could better outline to us, reflect upon these differences than you? Can you just summarize your op-ed and maybe go further if you wanted to develop it?
Yeah, thank you so much for this kind invitation. It's really nice to have the chance to talk to such knowledgeable people and discuss what is really a very challenging judgment. And I think it raises challenges not just to this specific issues of competition law, but also generally to matters of EU law more broadly. I think that already in this discussion, we've heard the main problem that people have when they're tackling this case, which is that, we first heard it being described as a discussion about, the primacy of competition or regulatory law. But then Niamh talked about it and she said, well, this is fundamentally a discussion about procedural issues, jurisdiction. And that is my main concern with this case, that people read the judgment and their gut feeling is this judgment deals with, if there is a conflict between regulatory law and competition law, which one should prevail. And that's not at all what I see in this judgment. In fact, one of my main problems with this judgment is that this was the big elephant in the room, and it simply did not address that at all. So in my view, the judgment basically says, look, there is an exclusive appeal mechanism, which is very specific to this directive, to the Railway Infrastructure Directive. It's a very fast mechanism. So, if you have a problem, ideally go to the regulator, let the regulator decide. The regulator should give you redress. This is an important point because in the case before the National Court, the regulator had not given them redress, even though it had declared the illegality of the tariff. So, go to the regulator, let him have an opportunity to solve the problem within the confines of regulatory law and achieve the solution which is in accordance with the objectives of this regulation, this directive. And then if that doesn't work, go to the National Court, right? But first give the regulator a chance to solve it. That sounds fine, but it doesn't really address the issue of what happens if the solution that is imposed by competition law is different from the solution that is imposed by regulatory law. And this problem arises at the level of the regulator itself, because some people will argue that the regulator itself has to apply competition law, not just regulatory law. I understand the argument that competition law has direct effect, but I don't think that as a matter of procedure, they're empowered to apply competition law. And one thing that is certain, they cannot adopt a negative declaration. So they cannot say that competition law was not infringed. That's very clear if it's Article 101 or 102. So in the end, you get this position from the regulator, which the injured party may agree with or may not. And then the injured party may want to go to court and say, well, they said that regulatory law was fine with this practice, but we think competition law is not fine with it. And there is nothing in this judgment that helps us understand what happens in that case, I think. So for me, that is the big gap. The other big problem that I see is the discussion of can a directive, because that's what we're talking about, can a rule of a directive which sets up exclusive competence exclude the invocability, at least for some time, exclude the invocability of Article 101 or 102 before a national court, meaning exclude the direct effect of EU law. This is the issue that Justin also addressed of the problem of can secondary law derogate primary law. And I'll let Justin take that thing, I guess, because he went more in depth into that part.
Thank you, Miguel, for summarizing your position, your starting position at least. Justin, Can you please reflect upon this note by Miguel?
Yes, absolutely. Thank you very much for organizing the panel. So my contribution centered basically on 2 points, which have already been addressed by the other speakers. So the first question to me is the one that Miguel addressed lastly, which is the question whether secondary legislation can ever, or sometimes, or under what circumstances, limit the applicability and the invocability of primary law. So this question seems to be a pretty straightforward one, because we all know that the treaties are higher order law. So if you think about this question in terms of the hierarchy of norms, then it should be obvious that a lower order norm, like some norm from a directive, can never detract from the invocability and direct effect of primary law. This is, after all, also what Article 263 TFEU says. Violation of any rule of the treaties is a ground for annulment of the specific instrument that has been adopted. Now, if you think about this a little more in depth, it turns out to me, and that was my main point in this aspect, that things are not so easy. In practice, we see throughout EU law all the time that secondary legislation in some way detracts from or limits the applicability of primary law. So the example I used was the sort of mainstream well-established case law that if a particular topic is subject to exhaustive harmonization at EU level, for instance, through Article 114 TFEU, then the subject matter should be assessed in light of the harmonization measure, not in light of the fundamental freedom concerned. So this is obviously some conflict between secondary legislation and primary law, where it is in fact secondary legislation that should be applied, especially because the EU legislature can move away from the case law of the Court of Justice as regards to fundamental freedoms, at least in some respect, right? So I think this question is really quite complicated. And here it's perhaps even more complicated because, as Miguel also outlined in his op-ed, this particular directive was adopted in the area of transport, Article 91 TFEU, which is not about competition, which doesn't really say anything about competition. And so the relationship between this directive and Article 102 becomes a little bit more blurry, I would say. However, as a sort of starting point, I would say the problem is that it is not at all clear to what extent secondary legislation can detract from primary law substantively, and also in this case procedurally, right, as we have already been discussing. And the second contribution I wanted to make in my op-ed is focusing on the question, can the regulator in this case apply Article 102 in the first place, which is also what Miguel already addressed. Now, I think this question would be looked at very differently by a competition lawyer and, let's say, a general EU lawyer or a general EU law perspective. In competition law, of course, we are all familiar with Regulation 1/2003, Articles 5 and 6, which really marked a shift, a watershed in comparison to the system of Regulation 17. So this conferral of competence to courts and national competition authorities to apply Article 102 is really important in competition law. But then if you look at other fields of EU law, actually the default position of the Court of Justice has always been that direct effect means that anyone can rely on the directly effective provision, and any national court and any national administrative authority is competent and obligated to apply a directly effective norm of EU law. So from this, let's say, general EU law perspective, it's not really clear to me that a regulator cannot apply Article 102 TFEU, especially if that article has direct effect. And then the second question, but that's something to discuss, I think, at a later moment perhaps, is if the regulator can in some way rely on Article 102, in what particular way can the regulator do that? Can it apply Article 102 across the board, or can it apply Article 102 in some limited way relevant to its competences?
Thank you very much, Justin. Niamh, what would be your prima facie reflection upon these two sets of views?
Okay. Thank you so much. So just some sort of off the top of my head type of reflections. I very much take the point that the judgment seems to be, while at the same time reaffirming the direct effect of Article 102, in essence putting up somewhat artificial obstacles to its application. I just wonder whether this is actually that revolutionary when it comes to Article 102 case law. I'm thinking when I read the case, I had sort of shades of something like Huawei, where the court says, well, Article 102 could be invoked here in certain circumstances, but only if the applicant can show they've gone through a number of different stages beforehand. So there's kind of the broader legal framework is relevant. You've got to first try, exhaust your local remedies before you go to Article 102. And in your op-ed, I think Miguel, you mentioned the Towercast case, which I thought was interesting, where it does talk about the opinion of Advocate General Kokott, where she says very clearly, obviously, the Article 102 continues to have direct effect potentially as an instrument of merger control, even 50 years after Continental can. But she then goes on to say, but actually things will be quite different if you have a merger control regime in place, which in a sense kind of codifies in an ex-ante form the application of Article 102. And that might allow us to, to pause before we kind of say, well, we have to be able to apply Article 102 in tandem. It might be a reason to kind of depart from that somehow. Again, the point about your point about conflict, and I really agree with you on this, that there is this sort of, in the judgment, it seems to say, well, we can find ways to minimize any potential conflict, and you've got a duty of good faith cooperation. But of course, that in no way rules out the possibility of having conflict. And I think I was always very struck by Advocate General Mazach's description in, I think it's the Deutsche Telekom case, as regulation and EU competition law as two obstacles, two barriers to lawful participation in markets, and undertakings need to make sure they comply with each of them. The problem is, if those barriers come into conflict, what do we do? And there's very little in the case law, I think, that suggests that. And I think, to me, Deutsche Telekom is a paradigmatic case of that, because the regulator explicitly was taking a decision which led to a pricing structure was held to violate Article 102, and it was doing it on social policy grounds, and that was something that was completely dismissed, irrelevant to the Commission, irrelevant to the court. So I find that a deeply problematic outcome. I don't know if it's unique to the DB station point. And I don't know whether maybe I will pause, but I could also, I think Justin's point about the applicability of Article 102 by regulators, I do. So I agree. I think is it paragraph 74 of the judgment, where the court says, seems to suggest that the regulator has a kind of an obligation to apply Article 102 sort of their own initiative. I'd be interested to see how that gets interpreted subsequently, and whether how wide-standing a view that is, whether they really, kind of in their day-to-day business of assessing the compatibility of these charges with Article with the provisions of Directive 2001/14, to what extent they kind of have to, of their own initiative, also consider compatibility with Article 102 and could make freestanding findings of incompatibility. I suppose if you look at it as a more general statement, I think maybe it's going to sound like a little bit cheesy, but it kind of had echoes of Echo Swiss to me, this notion that Article 102 would be part of the kind of general public policy in EU law, and when you're exercising a function, a sort of an adjudicative function, even in another area, you need to make sure that your outcome is compatible with what, in that case, Article 101, in this case, Article 102 would require. And it also, I wondered whether we could kind of draw some parallels to Slovak Telecom, and the most recent Slovak Telecom from March last year, where the Court of Justice says, essentially the regulatory framework is a relevant consideration. It's not determinative of the outcome under Article 102, but it's certainly a relevant consideration as to what would be lawful or permissible conduct in a particular area. I wonder if you kind of look at the reverse of that, whether the compatibility of charges with a regulatory framework, you could also take into account, are these acceptable under the regulatory framework? Something that we could potentially factor in is whether we might have an Article 102 problem in the background with the kind of pricing levels. That's probably more difficult to do because the directive is a lot more prescriptive as to what you can take into account with the charges. But I think that there's an argument for having maybe not the seamless web, but for having some degree of, I suppose, consistency across these different areas of EU law. That's initial reflections. Thank you.
Miguel, can I ask you please to reflect upon these points by Justin and Niamh?
Yeah, of course. It's it's such an interesting discussion and so many levels. It's so complex. It's easy to get lost in all the different sub questions. As I was listening to Justin and Niamh, I kept writing down more issues that I thought, well, how interesting. Let's think about this. Let's think about that. I think I take the point of Justin's that there is an obligation on any public authority to apply all EU law, and that means any EU law that has direct effect, and that means also applying Article 101 and 102. The problem is that I don't know how that happens and how that translates in practice. And Niamh was already raising this point. I don't know how that translates to in practice. I think that's one of the main problems of this judgment, is that it's kind of this beautiful kumbaya, pie in the sky kind of thing of let's everything will be harmonious and everything will work out, where that's not the role of the law, right? The law is there to give us a solution for when things go wrong, not for when people behave well. So that worries me. So for example, are we going to have if the railway NRA now has to apply Article 102, does that mean that they're going to start having a section in their decisions identifying the relevant market, establishing dominance, and then doing an assessment of what competition law would require them to do in that case, so that they can compare that to what regulatory law requires them to do? Are they really going to start doing that? Are they able to do that in all the member states? Do they have the expertise to do that within the regulator? I don't think that this is necessarily the case. And there are all other sorts of practical problems that come to mind. Again, the judgment obviously was thinking very, very much of the specific case. Let's remember that in this specific case, the NRA reached its decision. It declared the thing illegal. And then there was an appeal, right? And the appeal, after 10 years, has still not been decided. So the court tackles that by saying, well, if the appeal has not, because the appeals can take so long, you don't have to wait. You don't have to wait for the appeal of the NRA decision in order to file, before you can file your antitrust private enforcement action. But again, how does that work in practice? So you have a decision that says that you do not have a right to damages, for example, that the law was not broken, including 102, which they cannot declare, right? They cannot include a statement that 102 was not infringed. So you'll technically can never have that, or it will be null and void. And then you go to the national court and you say, I think 102 was infringed, and you're always doing a standalone case. And then 10 years later, the decision gets annulled, and there's another regulatory decision on the same issue. You can have the reverse. You can have a person who thinks, okay, I'm entitled to damages, and then 10 years later, it turns out the decision is annulled. They're not entitled to damages, and they should have gone to court. And what now? The right is time barred? Are they supposed to have filed a private enforcement case just in case and suspend it while the other one is being so? I mean, yeah, on a theoretical level, these things are pretty, but when you start imagining the complexities of how this plays out, it's that is the part that really gets to me. And then as I was listening to Justin and Niamh, my mind also went to Wouters case law, which I don't think has been mentioned yet, which is also basically what we're talking about here, right? We're talking about a conflicting values, and that's maybe a question that I wanted to put to Justin, which is, when I don't know that case law as well as you do, the general EU case law about the primacy of the conflict between secondary law and EU law and primary law. So I would ask you, is it possible that in that case law, we could interpret it as saying that secondary law was only allowed to derogate from primary law when that secondary law had a basis also in another rule of primary law? And so basically what we were identifying was a conflict of primary laws, even though one was implemented by secondary law, and saying this one should prevail, this primary law concern should prevail over the other one. Could that be what is happening, or do you think it goes beyond that?
So I think it's a very good question, but I wonder so I wonder then, in what situation would that be an easy question? Because any secondary legislation has a basis in primary law. So let's say it's now transport policy. And so if you frame it like this, you could say, well, but actually there's a conflict between transport policy and Article 102, but that's not really the case because Article 91 TFEU doesn't really say much. It just defers to whatever the legislature decides to do in order to liberalize transport and so on, in this case, railways. So I think you would have a problem of indeterminacy there. It's really only because the legislature has used its competence to adopt specific rules, including specific institutional allocations of competence in relation to railway infrastructure, that we have this case. So I'm not sure if that is if that's a way out of the conundrum in a way. One other thought I had, I don't know if any of you has any other views, because I had one other.
I wanted to use this opportunity actually, Justin, and to maybe not to rephrase Miguel's question, but maybe just to kind of to shape it from my perspective, because we can, okay, as a kind of an observer, you can clearly see the logic, the formal logic behind your way of reasoning, and which basically says, well, yes, seamless web, everything is interdependent. You can create from the textual flow, not everything, but there is kind of discretion or flexibility to articulate different ideas depending on the interests of the party, which is, I wouldn't by no means pathologize this. It's kind of this description, or not the fact which you describe. But from the perspective of practicality, what would be your reflection? Do you stop with your thinking by just simply stating the condition in which we all are, with this kind of relative indeterminacy and cacophony of different legal orders interpenetrating into each other pretty much in a random way? Or you have some kind of recipe how to at least to mitigate this less clear condition?
So I would have two answers. The first answer would be no, I don't have a recipe. But then what else is new? Because this is not an issue specific to this case or to competition law. This is an issue that is pervasive in EU law. Think about the easiest Article 34 TFEU case, something about mandatory Sunday closing times. Is it a measure having equivalent effect, and so on and so forth? If yes, is it proportionate? I mean, we saw in the 80s and early 90s that dozens of UK courts reached diverging outcomes. The Court of Justice reached diverging outcomes in various cases, and it was all a big mess. So in some way, I don't have a recipe, but that is because, to me, all interesting questions of EU law are about these kinds of situations. Then my second answer would be, well, maybe I do have a recipe looking at this specific case. And my proposal would be not to interpret the judgment in the most worrisome way, which I take Miguel's point to be. If you read this judgment, and we're going to look at all the ambiguities and possible problems that it could entail, sleeping will be difficult tonight. But let's try to interpret it in the most charitable and least worrisome way. So then, would it not be possible that the paragraphs of the Court of Justice where it speaks about the obligation or the possibility for the regulator to apply 102, so paragraph 74 in particular, would that not simply mean that if the regulator sees or comes to the conclusion that these charges would be abuse of dominance under Article 102 case law, and that might be because one of the parties presents this argument, then that's a very strong argument, which weighs very heavily for the conclusion that they also violate the directive. Not conclusive, but a very strong indication. So the regulator doesn't apply 102 directly, but takes the analysis on the 102 into account. Then moving on to the second situation where the national court has to rule on the 102 case and needs to cooperate in good faith, etc., etc. Would that not simply mean that the national court cannot ignore the regulator's decision, needs to look at it, needs to see what the regulator decided? If the regulator decided that these charges are contrary to the directive, it doesn't prove that they are abusive as well, but it may suggest that there is something not entirely going rightly. And so perhaps this judgment is a workable judgment because it merely points to all the relevant institutional actors. It points out to them that they need to take into account each other's decisions in their respective fields of competence.
Niamh?
Yeah, so I very much agree. I think the extent to which this is problematic depends upon the extent to which it's the problems are likely to materialize in practice, and that's a slightly an unknown question. But maybe I would be a little bit like Justin, slightly more positive, because I don't think that you are likely to see courts coming to very, very divergent judgments in practice, or regulators and courts, not least because if you kind of look at, unless something's going very wrong, I think within the regulator, because actually the directive says that the regulator, there's freedom at a member state level to essentially set prices that either allow for the recovery of direct costs or up to the recovery of total costs. So, you know, which could be a higher or lower figure. That to me, to the extent that it's a 102 case, but it's an excessive pricing case, even allowing recovery of total costs seems very, very far from the threshold of bearing no reasonable relationship to the economic value of the product. So I think there'd have to be something quite, you know, strange going on for fees that were sort of potentially were acceptable under the regulation, but to be unacceptable under Article 102. The point about just to kind of Miguel mentioned the possibility that you would end up in a situation where for each determination of whether railway access charges were compatible with the directive, you'd also have to kind of go along and do a parallel 102 investigation, potentially to find markets and find dominance, etc., etc. The one thing I did notice in the judgment is a slightly throwaway line that all sort of natural monopolies are by construction in a dominant position in relation to railway undertakings, not citing anything there. That's probably true in practice, but as a kind of default rule seems slightly problematic, that you could kind of automatically jump straight into kind of the second stage of asking, is there an abuse based merely on the fact that you kind of have a national monopoly at member state level? So I just, I wonder whether anything will follow from that. Thanks.
Miguel, if I can complement the questions or reflections made by Justin and Niamh, and maybe you can highlight to us, if you know, there was kind of this 10 years kind of another elephant, the second one in the room, which was, is there any, so what is behind in terms of factual circumstances? Is it purely conceptual clash or kind of a set of coincidences, unlucky coincidences, or there are some really kind of strong industrial or kind of regulatory sectors which have fundamentally different perception and stakes in this battle, and we only see purely juristic tip of the iceberg of this conflict?
Yeah, I'm not sure I understood the entire scope of your question, Otis, but you were referring to the 10 years that this lasted. If you meant why is it being so complicated? Why is it taking this long? I think that I don't know enough about the facts of the case to give you a proper answer. But what I can tell you is that if this happened in Portugal, I think the exact same thing would happen. If you go to court challenging a decision of a Portuguese NRA, you're going to be before the administrative court for at least 10 years. So that doesn't surprise me. One of the things I find now listening to Niamh is, we're seeing these problems pop up in practice all the time. I do a lot of antitrust private enforcement, and my perception is that every time we will now have it's already happening. I already have examples of that, but in the future even more. Every time we have an antitrust private enforcement case relating to a services in some kind of regulated industry or sector, the defendants are going to raise the issue of, well, this has to be addressed by regulatory law, not by competition law. You have to recognize the primacy of regulatory law. And here, look at this case. They said that first you had to go before the regulator. And that goes to the final question, which I addressed in my op-ed, which is, does this extend to other sectors? And I really don't know. I think that it's really, really specific, the reasoning that the court followed. It's based on case law, which is also very specific to this railway infrastructure directive. It has to do with this specific appeal mechanism to solve this kind of disputes, which does not have a parallel in other directives, as far as I could find. So, I guess I'm the most pessimistic of the four of us, possibly, concerning what this case is. And I guess for me, the big positive aspect of it is that it is so limited. That it is a railway infrastructure directive case. I don't think that you can extrapolate it to others, but it will be discussed, right? They will be trying to extrapolate this to other sectors of regulation. And the final question that I remembered now, that I don't think anybody raised so far, the court is saying to the NRA, you have to create the situation would have existed in the absence of this infringement. You have to ensure that this person's harm is remedied. But in most member states, constitutionally, the NRAs will not have the power to award damages. They have the power to declare something invalid, and therefore you have to restitute undue sums, but they do not have the power to award damages. So that's an interesting question for the court. With EU law, is the court saying that EU law requires this railway NRA to also award damages, even if its constitutional order says that it shouldn't?
But what would be the practical implication? So what the court will do following on the judgment on the preliminary reference? Does it provide a clear answer, at least in this specific case, or we continue being dependent on this duty of sincere cooperation? So how do we read this duty of sincere cooperation in this case ultimately?
Look, I really don't know. In this case, what the court said that should happen didn't happen. Right? So you had a decision that was supposed to order restitution. It didn't. You have a decision which at least declares the illegality. So basically, I don't know, but I guess if I were the national judge, I would say, okay, well, they went before the national regulator. They tried. It's been 10 years. They still don't have a res judicata decision. According to this judgment, there is nothing that prevents me from deciding this antitrust private enforcement dispute. Now, that's fine, but then you get to another problem, which is, what is the judge going to do when he decides, you're right, you're entitled to damages? Because is this NRA going to now alter its decision or adopt another decision to comply with EU law to say, oh, and because this practice is illegal, you have to restitute damages? And will that decision then be appealed again? And will there be more 10 years? And will the court risk the issue of double payment for the same infringement, right? Ordering damages in antitrust and then damages being ordered under regulatory law. this is one of the big problems of the interplay between these two things, which I think that you can find injured people being stuck in this quagmire of having to wait for the administrative appeal to be over before they can solve the competition law dispute, which would usually be faster.
Justin, before closing our hour of conversation, I wanted to ask you to reflect upon the latest points by Niamh and Miguel, please.
Yeah, so just one very minor point in response to Miguel's point about the competence to award damages. So is this not then a flaw of the directive? Should not Article 30 of Directive 2001/14 have expressly stated that the regulator also has the competence to award damages?
Can I also come in with just a very final point, just responding to Miguel and his concern that this is just kind of creating more, I suppose, spurious defenses for defendants to kind of throw at courts to avoid this. I take that point. I think we're talking about something very specific here. We're talking about, claims that are being brought under Article 102 alleging that prices amount to a violation and abuse of dominance when the prices have been set, or at least, approved under a very specific regulatory framework, which the court has in all of the cases since CTL Logistics been very clear. It's a very specific, very technical activity, balancing optimal use of the infrastructure, non-discrimination between different parties, trying to enable fair competition. And so I think that, I think there is an argument that actually the regulator is sort of better placed to deal with this. But the court in DB Station is very clear that this is time limited. If the regulator doesn't get their act together within a reasonable period of time, then you can skip that step. And so if you don't have to wait for 10 years. And so I think it was your piece which kind of raised the question of what's the reasonable amount of time you should be expected to wait? Is it just 2 months? And I don't think that that's an unreasonable outcome here. That if the regulator doesn't comply with the regulatory obligations, well, then you move on to Article 102. One final thing, which is I'm always struggling to try and find 102 cases where you can kind of shoehorn in a sustainability or New Green Deal type of element. And I wonder, could this be that aspect? Because one of the, I suppose, outcomes of this case is that if you've got the kind of incumbent preventing liberalization of railway markets at a member state level, well, then actually that could have sort of implications in terms of environmental protection, pollution, climate change. So maybe we can claim this as a sustainability case indirectly.
So the room for interpretation of this case appears to be relatively wide. So looking at the future, maybe Miguel and Justin, you also wanted to reflect upon the evolution, not specifically the importance of this case to the antitrust doctrine and EU law, maybe more generally.
Justin, do you want to go first?
Sure. So to me, in a very brief nutshell, this case shows, I think, that lots of things in EU law are still pretty interesting. So we are talking about this for more than half an hour, and our conclusion is lots of things are unclear, and we basically don't know what this judgment means. So compare that to, let's say, US antitrust. Miguel, in his op-ed, referred to the Trinco judgment. I mean, things are very simple and very boring over there, right? So in this respect, I think from a practice perspective, lots of reason to be unsatisfactory, but from, let's say, an outside perspective, and we will, of course, talk about the DMA and so on, this nexus between regulation and EU competition law, I think, is still covered in clouds to a large extent.
I really love Justin's point here that basically we need more judgments like this one to make sure that the legal services and the academic markets continue to thrive in EU law. Yeah, that's true. I guess my approach to this is that although I'm also a lawyer and it's nice to have business, my approach to this is I would really like the court to give us more clarity. I think that this case, every now and again, the court throws us a curveball or adopts a judgment where it has such an amazing opportunity to address a big problem, and it just goes sideways and says, no, you know what, I'm just going to sidestep that. I think this was one of those. It was a missed opportunity. I take Niamh's point that in practice, in the future, the impact of this specific case might be quite limited, but it will have huge repercussions, I think, in terms of arguments that will be raised and legal uncertainty that will be created in many cases in other areas. And I think that was unnecessary. I think it could have been easily avoided, even if it was just with a statement of, you know, this is about this, it's not about that. Don't interpret this judgment as being about that. We're just talking about this. Sometimes I think it would be nice if the judges were to think about how could we make this even clearer, I guess is what I'm saying.
The judgment was surprisingly succinct. Only, I think, a little bit more than 10 pages, which, or I think 100 and something paragraphs, which is quite, you know, they had more, and they spent more than half of it by just citing the relevant national law. There was definitely room for bringing this clarity, if such clarity does exist in principle. And after reading your texts and after listening to your reflections and Niamh's reflections, it looks that we are entering, or we are kind of establishing ourselves into this relative indeterminacy mode, and ending this conversation, knowing you, all three of you, as brilliant thinkers. I invited you based mainly on this reason. You are real authorities for competition law, people and beyond. And knowing that students might be interested in this rather narrow conversation, I wanted to ask your views, maybe your recommendations for those early graduates, or maybe who are still doing their law degree. Maybe you notice from your your experience, there are new trends which are not very well articulated in our academic or educational systems. Bring some, just maybe that would be a nice opportunity to mention these recommendations to our younger audience, if I may ask you for this. Niamh, do you want to go first, maybe?
Yeah. I mean, I guess I would say anything that's not just digital economy stuff, because I think there's a lot of people, Alice included, who have written some really brilliant stuff on that, and it'd be nice to kind of move beyond it a little. This, I think, is a neglected area. I think that there are some very kind of unsexy areas of EU law where it's quite regulation heavy, or it's sectors like transport or energy, where they're very practically important, but people are kind of, it's like slightly shinier sectors like pharma or digital markets. And I think it would be wonderful to have some more interesting work done on these very important, but maybe more quotidian areas.
Thank you very much, Niamh. Justin.
Yeah, I fully concur. Don't do digital platforms. If anything else, no. So I would say what I take away from this case, but in a much broader context, is it's worth looking at institutional and constitutional questions in competition law and regulation more generally. So digital platforms, very interesting. More economic approach and so on, all very interesting. But we know that stuff, at least that's my personal view. It's been done. Lots of more things can be done in these areas. But questions which have really been underexplored in, let's say, the past decades, it seems to me, are the relationship between constitutional law, legal theory on the one hand, competition law on the other hand, and also institutional questions. So not what is the best interpretation of Article 102 or whatever, but who should decide on this question? Who should be given the discretion to decide what Article 102 means, or how this directive should be applied, and so on and so forth. These institutional questions, I think, are crucial and very much worth exploring in more depth.
Thank you very much, Justin. Miguel?
Yeah, well, I'll try to say something new or different. I think that one of the areas that I'm seeing, one of the issues that I'm seeing arise, but maybe my view is distorted because I'm doing a lot of consumer cases recently. But one of the areas that I'm seeing come up more and more is the problem of access to justice as it relates to economic questions, meaning the economic viability of going to court and being successful and what it takes to do that. We had a brilliant opinion from AG Kokott on this already recently, and because of the incredible number of antitrust private enforcement cases that are being litigated all over the EU, and you're having judgments of some courts saying, "Oh no, you can't just come here without an economic study. You need to do an economic damages quantification, which costs tens of thousands, if not hundreds of thousands of euros." And you have to do that even if you're asking for 1,000 euros in damages, and then you can't get that back in the end under some rules of costs of some states. So I think that is an area that is under discussed so far. It's fundamental rights, but it's also EU law. It's also principle of effectiveness, and I would love to see more research on that.
Thank you very much. Niamh Dunne, Justin, Lindeboom, Miguel Sousa Ferro, thank you very much indeed for your time and for sharing your thought about this problematic and very challenging case. It's a pleasure talking to you.